friend of mine was sharing with me last week a concern he has. He and his wife have been divorced about 10 years. They have children, the oldest one being a sophomore in a local high school. And everything has gone well through the years. I mean, they haven't had any issues for a long, long time until now. And she is going to be relocating about 100 miles away. It's still close enough for him to be able to see the children when he's supposed to. But the oldest son is not wanting to go. He's wanting to finish high school here. And he was just wondering, would this be anything a judge would consider having a hearing on? Is there, in your experience, would it be worth his while to even try to gain primary custody of the older child, because she is not willing so far to let him stay with the father?
Thank you for your question, Sam. Melissa, do you want to share your advice with Sam?
Yes, sir. When you're dealing with a divorce, child custody, child visitation, and child support is always modifiable. And so a lot of times that you do have to come back as the children get older and adjust these issues. With the child being a sophomore in high school, you can go back and say, hey, I want to live with dad, or I want to live with mom, the spouse that's not currently raising him. The question becomes is, sometimes it's really going to be left up to your judge. Once a child turns the age of 12, that's just one of the factors to change child custody, which of the Albright factors. But some judges make you go through the true standard three-pronged test. Has there been a material change? Is the material change adverse to the minor child? And then can one spouse beat the other spouse on the Albright factors? But some judges say, hey, look, as the child gets older, his voice gets louder. If the child is 16 and says, hey, I want to go live with dad, I want to stay here, I want to finish up my high school year, I don't want to move 100 miles away, then the judge will probably let them.